Lords, may I?
Yes, please, carry on.
So, my lords, yesterday I had just commenced. I had placed before my lord that NCTE was the academic authority which had been appointed under the statute as being the authority which would lay down the minimum qualification for appointment of teachers, my lords. That is the NCTE Act read with 23 of the RTE Act. My lords, I had also shown to my lords that provision under the notification, the eligibility provision at 10, and then at 11, that how that was valid for a period of 7 years, because there is going to be a change in the requirement of the qualification. However, that's now done for lifetime, so I must bring that to my lord's notice.
But that clause says maximum 7 years.
Yes, my lords, but it is now
And they change. But
NCT has changed.
Yes, NCT changed.
Yes, my lords. NCT has changed it, so therefore I cannot
That's right.
do anything about that. Yeah, but it also notices that there should be a TET exam once in every year. And it is an,
That maybe you know the interpretation of this salvage is discretionary. You know this because in all the so many cases of this 41,
please, my lord.
where this issue has been considered that the
Yeah.
case of the promotion shall be considered
Yes,
on year-to-year basis.
on year-to-year
This
basis.
has been interpreted so hardly. This is
Yes,
not
my
a-
lord. My lords, I'm not on that aspect. My submission is something slightly different. I say while it is recognized that the exam should be held year on year, it's also an admitted position that between 2016 and as on date, exam has not been held. So it is the background on which I wish to make my submission. I'm on that particular aspect of the matter. Now, my lords, what I wanted to show was that the state had the discretion to consider the candidates who had obtained the TET certification. The state does have that discretion under that eligibility test 10, which I have shown yesterday to my lords. My lords, I want to state that there are 7 states which have accepted CTET as a qualification. 89. Yes, just give me that note of the 7 states.
How this may be beneficial here in this point,
My lords, it will be beneficial.
interpreting the law,
Absolutely. My lords,
how it is beneficial.
it will be on the aspect that the state does have the power to accept CTET as one of the
That power, if that is under the law, please show them.
When that
Would not
power-
make any, whenever there will be challenge to it, then we look into.
My lords,
That power
that
accept.
comes, that, my lords,
This
is,
would be a point of discrimination, no?
my lords,
But it is not at all your plea ever, anywhere.
my lords, it's my plea in the writ petition. It's my plea in the writ petition.
So that you have
Yes, my
taken
lord.
this plea of
Yes, my lords.
discrimination.
No, I have taken a plea that said CTET be recognized.
He recognized a different thing.
Yes.
What point you want to converse here is that out
No,
of
no.
28 states in India, in 7 states, the state government has notified this.
My lords, I wish to,
What we can presume it, that you
No,
want to take a plea of discrimination, that
No.
once it is being adopted in the state of Jharkhand, there cannot be any arbitrary exercise.
no, my lords,
What we are thinking of.
yes, my lords, I'm sorry, then I did not complete that particular aspect. My submission is slightly different, my lords. My lords are right, it can be looked as discriminating, but that's not what I'm submitting. I am saying this, that there are states in the country which have accepted CTET as being one of the minimum qualifications. I'm not saying on a principle of discrimination, because it will depend from state to state whether to accept or not to accept. What I am trying to say is that CTET has definitely come to be recognized by the states as one of the minimum qualification for the purpose of consideration of appointment to the post of a teacher, where states may not have conducted the exam. For example, in Assam also, they had not conducted the exam. They accepted
Does it
CTET.
work here?
My lords, it
State
works.
Discretion.
The state here also exercised that discretion is
When
what
it
I am
was-
trying to
when
say.
it was exercised.
My lords, I'm going to answer that. Just give me 2 minutes.
That is the only point, ma'am.
My lords, that's
That
my,
is the
that's,
only point here.
yes,
Suppose we are
Yes.
coming to the guideline, clause
Yes.
10,
Yes.
applicability,
yes,
then the guideline specify a specific procedure.
yes, my lords.
And in terms of that procedure,
Hmm.
you can adopt. We are not going to answer and embark upon
Hmm.
that the state is authority or not. But at present, we have to say this much, that in a circumstances in which that can be adopted?
My lords, I will answer that.
Please answer this much only.
I will-
That is the crux of the matter.
I will come back to this particular point. Please allow me later, but since my lords have put a question to me, I must answer that straight away. Can you pass that note down? My lords, that's on a position of twofold that my lords have put to me. One is the change that has been carried out in the advertisement. That's one aspect that my lords are looking, and the state having done that. My lords, these are two facets. Now, I wanted to place before my lords that these particular writ petitions, which I want to say have been filed, my lords, they have been the first writ petition. Would my lords see my paragraph B on this? We just put a small note together, my lords, on the factual aspects at least. The first writ petition before the High Court came to be filed on 7th of November 2022, which is the Suraj Bihari Mandal petition. After that, petitions came to be filed. There are 4 of them here, and the last one on 8th of May 2023. 18th of May 2023. In all these petitions, there is a common prayer that the state has not held CTET, so please recognize CTET. Now, my lords, please, one thing I must make out here very clearly. We are all residents of Jharkhand. We have gone and taken our exam, either the CTET exam or in the neighboring states, while the state of Jharkhand was not conducting the exam. So that is an important facet, that we are all residents of Jharkhand. We do know the local culture, languages, etc. from Jharkhand. And that's also pre-qualification that the state has now put even while granting that little relaxation. Now, my lords, this particular advertisement came to be issued on 19th of July 2023. That is advertisement number 13. This, my lords, will find the date in the counter. This has been mentioned at page number 169 of additional documents, that this advertisement is dated 19th of July. In the interregnum, my lords, when these writs had been filed, counter had been filed by the state of Jharkhand, the advertisement came to be issued. What I'm laboring now to point out is, between the judgment of the High Court and the amendment made subsequently to the advertisement, the state of Jharkhand had itself carried out at least 6 or 7 amendments to the advertisement, extending the time for filing and applications, extending the age limits, and other concessions to that same advertisement. So, my lords, the extension which was granted after the judgment of the High Court was not the first extension for the purpose of filing of the applications. So, on that aspect, where it has been stated, so, my lords, please, there is a small series here. If I may just quickly run this.
This is not much relevance.
My lords,
Madam, we are asking only one question.
please, my lords.
Please apprise us on the facts of the case
I am.
that as per clause 10
Yes.
of NCTE guidelines,
Yes.
when the exemption can be granted. And this procedure has been adopted. And in fact, this was a work of the state government. The state government was not in a position to discharge this onus.
Please, my lord.
We have already heard Mr. Maninder Singh as well as Guru Krishnamurti. Even
So-
because of you are one of the, you were the petitioners before the High Court. So therefore we are hearing you. So your contention may be hardly whatever you have said and how far it can be done. That is all. We can understand.
My lords, then can I just break this submission up into 3 points, answering the first query that my lords have put to me first, and I cannot put it beyond
Anyway,
that.
whatever you want to
Yes.
do it, we
So, my lords-
have already given you half an hour.
My lords, I will stick to the timeline
Then
that
we
my lords
have already
put to me.
spent. We
My
have
lords,
given
I will
essentially
try.
We have given today,
Yes.
otherwise we would have.
My lords, please, I would submit this, that it is within the power of the state of Jharkhand to amend its rules to bring in CTET as one of the qualifications. As of today, there is an amendment. The rules have been amended, which have been amended as on January 2024.
29 January.
29th of January, I'm grateful. Once the rule has been amended and the said rule is not a subject matter of a challenge, it definitely cannot be challenged. by way of a side wing by filing an IA in this particular petition for the purpose of challenge. The necessary process has to be followed. That has not been done. Once the rule occupies the field today, unless and until that rule is set aside by a court, my lords, this will be my submission. My lords, that rule today operates. I come to the second limb. There is no challenge, so the rule does operate, and the rule recognizes CTET as one of the minimum qualification. Number two, the rule is under Article 309. Again,
Yes.
this is my first submission. My lords, my second submission to my lords is the submission that the rules of the game have been changed after the game has begun. Because if there is an occupied field and there is a legislation or a rule today that prescribes CTET as a qualification, I will place before my lords the material to show that it cannot be said that given the advertisement of 19th of July 2023, or that the rules of the game have been changed, or it has inured to the prejudice of the other party, to the petitioners here. And I submit this for a reason, that by a line of judgments my lords have held, that the commencement of a process would have happened if the exam had commenced or the parties had participated in an examination. Here, on 19th of July, when the writ petitions were already pending before the High Court, only an advertisement was issued. First of all, there was a pendency of the writ petitions. My lords, my second submission is that while an advertisement was issued on 19th of July 2023, pending 4 writ petitions on the issue, the state itself chose to make at least 6 amendments, whether it was an amendment to the age. Yes, my lords, I've given out a list also to accommodate various persons,
Yes.
which is set in this particular note. Now, and the state also extended the time prior to the judgment of the High Court for as being the last date for submitting of applications. And this is until the judgment of the High Court. So the state,
Not like that. The time was extended,
please, my
that is after the judgment of the High Court.
no, my lords, it had been extended even before. This is here. My lords, it is here. I have put the number of the notifications. Yes, my lord. Yes, my lords. My lords may turn to bottom of the page, the first amendment, age relaxation. Then, my lords, name change. Then, my lords, please turn to serial number D. Serial number D on the page number 2.
Yes, serial number D.
Yes, my lords. Extension 1. 8th August 2023, before the judgment of the High Court, online form submission deadline was extended to a new period from 16/8 to 15/9. Then, my lords, the next extension, my lords, will find at serial number F. This date 6/10, which was the last date given previously.
It's not relevant for us. We are only concerned only on the point of CTET educational qualification.
My lords, so I would.
Please, madam, please refer that.
My lords, I am on that aspect. I say,
Come on that,
so,
when it was extended.
yes,
What is this writ petition 4049 of 23?
my lords, that is,
It's not mentioned in the list
It was about those paragraphs.
because this is in reference to some writ petition.
Order we had shown, it was about.
There is.
my lords, these are those para teachers. That is that writ petition. That is where that order came. It was shown to my lords yesterday. So we just put it there for the purpose of completeness. No, my lords, just give me a time to formulate this particular issue. I'll leave it at that. My lords, my submission is this.
We are saying directly come on the point.
My lords, I'm answering
The
that point.
request is this.
My lords, my submission is this. When only an advertisement is issued and pre the judgment of the High Court, there is been extensions granted to that particular deadline for submitting an application form. After the judgment of the High Court comes, there is an extension that is then granted for the purpose of submitting the application forms. So everybody who comes into the zone of consideration with that extension of time that is being granted and apropos to that particular amendment that is carried out to the rule is eligible to participate in this teacher's appointment exam. My lords, having said that, once the rule is in place, extension having been granted of the deadline on which an application has to be submitted we are eligible now to submit our applications to participate in the teacher eligibility exam because by virtue of an amendment to the rule, CTET has become one of the minimum qualifications or eligibility criteria to participate. But having said that, I would point out that this minimum eligibility criteria has been buttressed by the state. It is not just that. The amendment notes that in addition, I can participate in the exam subject to two factors. One, that I'm a resident of the state of Jharkhand. Number two, I have taken that particular exam either from an adjoining state or I have taken a CTET. Number three, that I will, at the first attempt, also qualify the Jharkhand TET. So therefore, the state has
That
actually,
means you are not, they are not treating you eligible as such.
my lords, they are.
Provisional.
My lords,
Number one. Number two, you have given the list of amendments in the
Yes.
advertisement.
Yes.
Even the state is not arguing this. There is nothing on record here.
My lords, these are,
Only one, not one was the latest amendment which you took place.
Not later, she has given 6-7 amendments.
I'm coming
Not
to that.
Lord, my learned friend.
That is not even the state of the state.
Come to
The
page 140.
extensions I argued, not up to six.
Argued? Where is the document on record, anything?
Lord, the one document was shown.
One document, not one. She has mentioned how much?
Lord, Lord,
An extension.
Lord, one sheet was given to your lordship to the last
This
extension.
is what the state is arguing.
Last extension is up to 6th of April.
We have to see all. What were the reasons for extension? When she is arguing. This is not even the stand of the state.
But the stand of the state is it stood extended up to 6th of April.
Last is good enough.
No, Lord, I'm saying that the list of dates will, Lord, we are putting it in our note. We'll give
List
it to
of
you.
date is good enough, Mr. Maninder Singh.
Lord, whatever
Yesterday, when the
This is the way the state is assisting the court.
when argument was being advanced, your saying was, last day was 6th of October.
No, Lord, I said that the-
Not like this. Please, Mr. Maninder Singh.
I'm not-
We always remember the things well.
I'm not saying.
The right perspective.
I only had submitted that it stood extended from.
All right, ma'am, please continue.
That's not.
Now, if my lords will turn to the advertisement itself. The advertisement fixed certain qualifications to be attained as of date of the advertisement and for certain qualifications to be attained on the last date of online application. So far as the eligibility is concerned, or the CTET qualification is concerned, or JTET is concerned, this will form on the last date of the application as per the advertisement. My lords will find the advertisement in the additional documents filed by the petitioners at IA 3446. My lords, it is at page number, the advertisement starts at page 35.
3447.
Yes, my lords.
Yes,
Which page?
My lords may turn to page 149.
49.
Yes.
Yes.
My lords, I have put out a tabular chart for your convenience also at page 3, but please turn to the advertisement itself.
Yes.
My lords, page 149, please see the topmost serial number 1. It will be mandatory, my lords have that. May I read? It will be mandatory for candidates to have passed desired minimum educational qualification by last date of receipt of application in the commission. Then the last date of receipt of application is 8th of April 2024. So I have to acquire a qualification which is now stands amended by the rules on 29 January.
Where is that other qualification?
Yes, my lords, please turn to page 150 bottom. This is an experience. And for some purposes, they have done the date of publication, but for this, it is the last date of the application. My lords, page 150 bottom.
This experience would relevant?
My lords,
Purpose of the present case?
no, my lords, I am only showing that the advertisement is conscious on a fact that certain eligibility criterias or requirements are on the date of the application of the advertisement, whereas the purpose of this particular minimum educational qualification or the eligibility is on the last date of the application. My lords, those are two different things. Certain.
Please, kindly come to page 138.
Yes, my lords.
Intermediate trained assistant teacher, class 1 to 5.
Yes.
Fine.
Yes, my lord.
The last column, minimum educational qualification
Yes.
from institute recognized
Yes, my lord.
in which the degree has been prescribed.
Yes,
Then
my lord.
after
Or, and then there is that
then they
TET.
have added and.
Yes.
So and would be part of the
This-
educational qualification then, if we look into like this.
So, my lords,
Then if we look into like this, then you kindly read one, which you are reading.
Yes.
Educational qualification.
yes, my lords.
Then kindly read this, this is prescribed. It will be mandatory for the candidate to have purchased the desired minimum educational qualification by the last date of the receipt. The application
Online
in the commission,
Yes,
in the commission.
yes,
That is the last date of submission of online application form to be considered as the reference of so and so.
yes, my lord.
If any candidate does not possess the prescribed education.
He'll be considered
qualification,
ineligible.
by this date, he shall be considered ineligible.
So, my lords,
Yeah.
my submission for your consideration is this, that on
That you
20,
have submitted after the extended date,
no,
and the last date of submission of the form
was
is
8th April.
whatever is invited, you submitted on that day. If you have on the extended date, then within this clause, your qualification must
Yes,
be dated.
my
as a
second,
qualified person.
my second
Your
limb of that, my lord, there's one more limb to that same argument, which is on 29th January 2024, by virtue of amendment to the rules,
All right, please come to
my,
the judgments, ma'am.
yes, so my lords, my
Please kindly come to
qualification,
the judgments.
my,
Stay on
quali-
your point. We have
Yes.
understand factual aspects. Come to the judgment if you want.
so my lords, I also wanted to show that on other aspects, they kept the date of the advertisement.
Madam,
This was the last
We
day.
have already given you time.
Yes.
We have, our request is, please kindly finish within that. We will not carry on this case after lunch.
My lords, I completely understand. Now, my lords, my three
Like
judgments.
already, you have already 20 minutes.
My lords,
That
my,
is why we are saying, and no fruitful point has come out by this time, except to say this advertisement condition.
my lords, there is a
It's come out
legislation.
fruitful
I am on the
points.
legislation
We are
today.
not saying anything.
I am on the
Totally.
legislation today. There is a legislation by the state, my lords.
And please give
Today.
us
Yes.
judgments, we will take. it.
Yes. Now, my lords, just give me the three judgments now. Just take out first Bedang. Give me the judgments now. My lords, I have the judgments which have been set out on my last page. I want the copy of the
Yes, you have
judgments
to
for the
read it
court.
from-
Yes. My lords, the first judgment that I wish to place before my lords will be the 2011-12 SCC, page number 85.
All of these advertisements are prior.
In all these cases, my lords, the advertisements were dated prior and there was a revision that was carried out to the advertisement. And this court held that the advertisement, the exam on the basis of the revisions is valid and can be held. It will not amount to changing the rules of the game.
The question to that effect is, what was the change, relevance
Yes.
of the change?
Inclusion.
There were inclusions that were made here.
What inclusion?
My lord's, inclusion of certain other category of candidates who will be entitled to participate. The competition was increased, just like in the present case, it is sought to be suggested that competition has increased.
All right, fine.
Yes,
We'll consider para 29 and 32, as you have stated.
Yes,
yes.
similarly.
And my lords, similarly, my lords will find in the other judgments.
Para 29.
There in the note. It's no relaxation. It is only the increase.
My lords, in that particular paragraph, the court has held that consequently, may I read that part, my lords? In paragraph 29. Particularly, when a particular schedule is mentioned in an advertisement, the same has to be scrupulously maintained. There can be no relaxation in terms and conditions of the advertisement unless such power is reserved. And in this case, the advertisement reserves the power. I will show that particular provision where advertisement has reserved it. Now, unless such power is reserved, such power could be reserved at a relevant statutory
All
rule.
right, we'll consider.
Palos, can I show the reservation of the power in the
We'll
advertisement
consider,
itself?
ma'am. We'll consider.
My lords,
Come
that-
to next.
My lords, can I show the
Come to
register?
next point, ma'am.
192.
My lords, may just take page 192 for a minute, please.
Behind. Push it.
My lords, page 192 bottom of that advertisement.
Yeah, advertisement has also been modified.
And the whole advertisement has been subsequently modified at least on 8 occasions, my lords, before even the,
Said, ma'am, you have said, please, go first.
My lords, bottom of the page.
Yes.
Commission reserves the right to change the schedule and the format of the examination due to unavoidable reasons.
Consider.
Then the documents listed.
Come to next judgment.
Then, my lords, the point on my lords, these three judgments are only on this particular aspect that an advertisement can be modified. There have been revisions to an advertisement and the court has upheld that. Now, my lords, there is an argument on the legitimate expectation that has been made on the other side. I would submit this that
I have on the constitutional bench judgment.
my lords, that is that CT Shivakumar judgment that my lords are referring to. And I just want to point this out, that in a line of judgments, CT Shivakumar as well as pre and post in the matters of judges' appointment cases and all, my lords have taken this particular view, that once an exam is held, the process has commenced thereafter. And if then a change has been made, it will amount to aspect of legitimate expectation. Here we are at a stage of advertisement, and advertisement
That
to
would
which
not attack.
that will not be attracted. That is my submission, my lords.
Cannot.
Yeah. Now, my lords, the other aspect that I wish to, my lords, the issues which will then arise for my lords' consideration, please take that first paragraph on page 1 and I'll close with that.
First paragraph.
Yeah, the very first paragraph, I framed the issues and I put them in the answer form. My lords, the petitioners did not implead any of the 4 writ petitioners which were pending before the High Court. They have not impleaded any one of them. Now,
These people, they come first time.
so petitioners raise any grounds, my lords, the ground that has been raised today about the aspect that their rights are being affected or that this is a change of the game once a game has begun is nowhere there in the SLP.
But then,
My lords, it's not there. It's not there. They have not taken the ground. And my lords, therefore, the pleadings get constrained to that extent. Pleadings can only deal with what has been urged. If a counter has to be filed, it will deal with what they have presented.
Madam, what you are saying,
Hmm.
did the petitioners raise any grounds as raised before this honorable court, before the High Court?
No.
So they were not a party in the High Court. No question of raising of that.
My lords, but at least the ground.
Come to next question.
My lords, but at least the ground. Now, this is very important. There is no challenge to the notification of 29 January 2024.
That you have said.
That I have
You
said.
understand, we'll consider this.
Yes, my lords. Now, my lords, the point is
When did advertisement dated so and so rules attain
attain
finality?
their finality. My lords, that I respectfully submit, they attain finality after, when they challenge this particular advertisement and they challenge the rules of 2022 before the High Court rejected that challenge and they filed an SLP. That SLP has been dismissed on 9/9/2024. So therefore, those particular,
Just clarify,
yes.
whether this rule of 29 January 24
Yes.
or
That has not been challenged. That was not a part of that. I'll answer that.
The advertisement was.
Today also it is not a subject matter of challenge, that particular rule.
Alright. So
It's-
that is not under challenge.
My lords, that,
Part of 22 rules was under challenge, as you stated yesterday.
yes,
If
my
I'm
lord.
rightly remembering if,
As on.
so that was, against that the petition was dismissed
Yes,
and SLP filed that too was dismissed.
my lords, only one thing that I may add here for my lord's consideration. Advertisement number 13 was also a subject matter of challenge. On one hand, you rely upon that advertisement today to say that after the advertisement is issued, you can't change, there you have challenged. That is it.
Oh, this be an 11.
It should be on.
Go on next.
Now, my lords, whether the petitioners have to, they disclose that they had challenged the same, my lords, I leave that. That's a part of my first part. I will not deal with that.
Next,
Now,
to the next,
my lords,
the petitioners have pleaded in SLP that they are challenging the amendments brought.
They have not pleaded. They filed an application.
Not.
They filed an application, nothing more. So that is not under challenge.
Most of the fulfillment of eligibility qualification. as-
They are. Because this has been a subject.
Mean, ma'am, this question.
My lords, the
that
fact,
Petitioners were aware
yes,
of the fact that fulfillment of eligibility of the qualification as on the last
accepting,
accepting application will be taken into consideration.
yeah.
But
There should be last date of accepting the applications. My lords, this, what I mean to say. My lords, my learned friend corrects me on the aspect of the rules of 2024 amendment 29.
29.
He says that when the rules were challenged of 2022, they were challenged with the prayer of all amendments to date. And now when they,
When those were challenged?
my lords,
Prior
they
to
were,
the amendment or before the amendment?
my lords, they were challenged prior to amendment to date. But the SLP was filed in the Supreme Court against that. And therefore, always an SLP will be an extension of that, and all those amendments have to be
Specifically
considered.
challenging. You-
Yeah, my lords, they may not, but what I'm saying is amendment to date is their wording. Yeah.
Consider your argument.
Yeah, my lords, I leave it there. But the last point that I was trying to make is that they had full knowledge that people had filed writ petitions, and the fact that there had been changes in the eligibility conditions consistently, even after the advertisement, including in January, and the exams were finally held on in April, May, and June. And the last date was 8th of April 2024. So they were completely cognizant, they had full knowledge about that. So this cannot be said that the rules of the game have. very, very quickly the matter. I want to point that out that I have already pointed out that they had full knowledge. Now, the three things that I want to state is that NCTE being the authority which has to provide the minimum qualifications in the matter of state of Bihar, which is before my lords, which my lords have kept it for after this or whenever.
The rules are challenged.
No, my lords, there. The High Court had specifically issued notice to NCTE. NCTE before, and High Court records it in his judgment, said that it accepts that the states can take CTET as one of the
take.
qualifications. Now,
It's not
Jharkhand has
that.
taken it.
Clause 10 says that.
Yeah, so
But
my
we are
lord.
only that there is a procedure. If the state says.
My lords, there is no procedure there in the sense, there is no other procedure. It is for the state to accept or not to accept.
That's right, but.
Here by now by legislation, state has accepted. My lords, I
That's right.
can't go better than
That's
that.
right.
Yeah, that I can't go better than that. So therefore,
That is all.
no, my lords, just two things more. Just let me just wrap it up. I'm wrapping it up.
Wrap it up.
Don't stop, okay?
Gift.
My lords, my submission is
gift wrap
this.
only.
Yes, my lords, it is going to be gift wrap with the bow. My lords, my submission is that in the Bihar case where NCTE, which is the authority, academic authority, says CTET can be a qualification for a state, I would say they can't be better than that because that's the authority that decides. Number two, my lords, I have a comparison chart here about paper that was done of JTET in 2016. Then the present JTET, which the state wants to advertise, which exam has not been held. What is the syllabus for that? And the CTET. CTET is actually higher than 2016.
But the state also admitted.
Yes, number one. Number two, my lords, I submit the languages papers are overlapping. Number three, I submit the languages that were taken by them in 2016 no longer exist in the JTET
All right, you
today.
have mentioned this in this, we'll consider.
My lords, this is not, I have a chart here. Let me just pass on this chart to you. And lastly, my lords,
We should dispense with filing the paper books.
yes, my lords, I
We should have
agree.
these papers like this.
Papers being given, it is, I understand
The
because.
system here,
No, it's a very situation.
unique system here, in fact. Like
Lords-
playing cards, you one by one, the cards come in.
My lords, may only one thing I may say, and I'm not being deprecating or anything, but when the arguments are taken for the first time in
Well, thank you
arguments,
very
we
much.
are also on a.
Paper like
on a-
this, how somebody will have the time to respond to us?
Thank you.
So my lords, I have a last submission here.
Yes.
That when we took the exam for this particular post as teachers, at that point in time, we have taken the exam, it's unqualified. There is no interim order that was granted restraining us from taking the exam. The only thing my lord said was the declaration of the result. That's all.
Subject-
When we took our exam, no, my lords, it was not made subject to the outcome.
In any case, list pendency. But
My lords, I am just saying this. And
We'll consider.
our qualifications are in fact
We'll
much.
consider.
My lords, can I have just one last line and I'll be greatly obliged for that?
Please.
My lords, I have to take a JTET also. I have taken the CTET. I am a resident of Jharkhand and I still have to take a JTET and qualify.
For all, are you making this statement?
I beg your pardon. My lords, yes.
Are you making?
My lords, for the petitioners before the High Court. For the petitioners before the High
Mr.
Court.
Uber Association,
My lords, no, they were individual
one
petitioners.
friend was individual.
My lords, they were other
And
petitions.
that man has already joined somewhere.
My lords, there are 4 petitions. There are 4 petitions. They're large number. Only one, but my,
Right, we'll consider.
yes, my lords will look at the impugned judgment. There are 4 petitions.
But JTET also?
Yes, for the,
no, you are not
Fine,
JTET.
CTET.
my lords, no.
You are saying that I am JTET also.
My lords, I am seated. There are others amongst us who are also taken the state TETs, which is maybe from Chhattisgarh
Neighboring.
or from Bihar, because the state was not holding anything.
Fair, no, that you are asking.
Yes, but my lords put to me for everyone,
Some of them may be seated, some of them may be stated.
and I am saying this statement for the petitioners. There are connected 4 petitions. Those are individuals.
Thank you,
They
ma'am.
are all individuals.
Thank you, please.
Yes.
Yes.
Just a few things, not taking much time, 2 minutes. My friends, for
Good, good.
today,
Thank you, within 5 minutes, not so.
Not even, my friend said about, your lordship also noted, the 7 states have accepted. We do not know under what circumstances, because there are clause qualifying when a
We are
state.
not concerned with 7 states.
Then we not qualification, my friend pointed out just one point, that in the advertisement, it says the last date of extension is the qualification.
Yes.
But here there is no qualification. How does it matter when the extension is also there? Still, there is no qualification as per the advertisement. Assuming there is an amendment subsequently, the advertisement has not been amended. The extension is prior to the amendments. And the extension date is prior to the the amendment of the rules. After the
What
rules,
is the law on that? What will apply?
Please, here is the point and you have to answer. Here is the point and please you have to answer.
yes, it doesn't.
What they did is, advertisement was there,
Yes.
initial qualifications have been specified.
I have said it.
Then thereafter, there is a judgment. Like of the record which you have challenged before us. Then they have invited the applications in the light of that judgment. The applications was invited in the light of that judgment of seated persons.
Absolutely.
Alright.
Yes.
So once after this judgment, when they invited these applications, meaning thereby that CTET would be deemed to be included within that. And if it is included within that, and if we read this page 149, that on the date of submission of the application form, and this date of submission of the application form has been extended time to time. 1, 2, 3, 4, 5, and it is last is 6th of April 2024. So now, in that situation, and in the meantime, amendment in the rules have been made. May not amended the advertisement, but because of the CTET, the applications have been invited, then this would be deemed to be a qualification within the meaning of advertisement.
My humble submission,
And the last date would be 6th of April.
the rules
So
are,
what is your answer on that?
one, the rules are not retrospective. Number one, the rule doesn't say it is retrospective. Secondly, only when the state had the power to amend or include anything extra.
309
Go to
amendment,
the root of the matter.
309 amendment is not under challenge. It's the amendment of the rules.
Have in fact filed.
Leave aside 10 applications can't be to challenge the rules.
Your lordships are seized of the matter.
We can't say that.
For your lordships, number one. Number two, when the
You
judgment
can
itself,
understand your point is of rule is not retrospective.
one, number two, the judgment itself is under challenge before your lordships. We are saying that relaxation itself is not permissible. 23(2) says, when is the occasion that arises for a state to take a relaxation and include another qualification? It says appropriate government conducted JTET. If you have the power, first of all, you have to satisfy that under 23(2), your lordship rightly pointed out. The third class is,
Is that a precondition for amendment of rules also?
No, that-
309, that's a statutory.
there is a relaxation of including CTET.
All right.
So
That we have-
that your lordship will have to examine. Then, therefore, according to us, and on this. Then on the arguments advanced by Mr. Maninder Singh yesterday on the two judgments, they are not applicable. Actually, they are distinguishable. So I have put a note on that also, I am passing on my submissions as well. And they were not on the selection. They were only on the exam conducted for TET. There was no process which started. There's nothing. So therefore, they are distinguishable on facts also. And 23(2), there has been no answer till now, And 10B, my friend said, a state government will mean any state government. So 10B becomes superfluous than the enactment as such.
Even any is there.
Yes, Lord.
Even any-
Then there is no.
Even any is there, but it would not partake the character of the state. You can understand.
Yes, that's all. Very well. I'll pass on.
It
this.
cannot partake the character of the state.
Yes, Lord.
A or any
Yes.
would not partake the state.
No, no.
We can understand of this.
No, it's about a state government.
But we cannot object the argument of the other
We
side.
can.
We can raise the argument.
No, that everybody is entitled to submission.
My lords, on 15th of February 2024, advertisement was amended. It's in my note.
All these.
My learned friend is not right that advertisement was not amended. It's in my note, 15th February.
1 second.
It is at serial number 3. It's in the note. And it is not being challenged. No, it's not. 15th February, it was amended. It is in my
Sir,
note.
there is no document on record for all this.
Because there's a notification of the government.
Keep it with you only.
With you,
Keep all documents with
Because
you.
what do I do? It hasn't been filed. I can't.
we will not rely upon those which is not with us.
It's a strange kind of a thing, the case is being argued.
This is where what we have.
We are also handicapped, my lords, but the point is we have to bring it to my lord's notice.
Strange.
Sorry,
Finally, one.
Sorry is the answer, Mr. Maninder Singh. How do we decide the cases like this?
Your lordship right, my lord, I can't have any, my lord, anything against it. You know, I vote.
That is all.
So
It
it's
should have been-
really strange. Never seen in more than 35 years, the way the cases are argued here.
Who have been filed along with the counter.
Never seen in High Court like this.
Your lordship is right, that there is a miss on the part, on our part to place.
And state also behave properly there, not like this. Right, then you fail.
Yes, please.
This is the last prayer.
My lords, I only request.
See the way the cases are argued, last court, this is the assistance we are getting.
Documents are now being given now.
This is why, what I told you, we are playing cards here basically. One by one, the papers are coming, one by one.
Hold on, that is happened at least in this.
No, this is the practice here, Mr. Mahendra Singh.
That, my lord, your lordship.
You know, we have also seen in 1.5 years.
We
Yes,
try
all right,
our
please.
best, we try our best. We are sorry, but
This is not the way, try our best.
my lords, I am sorry, I apologize, but
Sorry is not the answer for this. The way the mess is being created,
All right,
you have mentioned there, no document on record, nothing.
We'll see what we can.
yeah.
You give all these notifications one by one.
I will,
Give us-
I'll put them in the same order of compilation and give it.
It
to
doesn't
my
know
lords.
it, the private
will.
counsel know there are amendments and
But
the,
your lordship is right.
very good.
Just put this in the same order of compilation and give it to the.
Yes, please.
I'll
Yes.
just take a few minutes just to respond only to what your lordships put to me yesterday. On that CTET information bulletin, my lords, I've put it together with my note so that your lordships can just see it.
Moral of the story is we should not put any question.
No, my lords, you must.
No, we should not put any question
Because
because then new
documents-
cards will come in.
Document.
We should only silently hear the case.
If I,
This is the moral of the story.
may-
Nothing in petitions, nothing in counter, all cards are coming in the court like this.
my lords, if we had the wisdom and the foresight of mind to imagine all the questions that came from the
We
bench.
should give the questionnaire first then.
No, my lords.
That
I'm just
practice
saying-
we started.
I'm saying it's
Paper
meant,
book should come to us, we prepare a questionnaire and send it.
my lords, it's
Yes,
meant,
please, what?
it's meant both ways. When we exercise our
Both
minds
ways.
in a different direction, we come up with
Now
questions.
you come with the.
No,
question.
that's what I'm saying. Your lordship put a question on CTET. We didn't anticipate that CTET comparison is something we should have anticipated. It is our fault. I'm just now placed the CTET bulletin, if your lordships can see.
Yes.
It's at page, it starts at page 12.
Hmm.
Right, my lords? Just come to page 17, 18, page 18.
Hmm.
Page 18, short title, your lordship sees in the middle. Short title. These rules will be called as Central Teacher Eligibility Test Rules 2011. So these are the rules, my lords. We've taken it from the website, in fact. So these are the rules. There's no separate rules. These are the rules. Now it becomes part of this bulletin, which they refer to as the information bulletin. Now in this, if you just come to page number 21, my lord. 21, these left side, nature and standard of questions, your lordships have that. Now, the second bullet point, the test items in language 1 will focus on proficiency related to medium. Next one, the test items in language 2 will focus on elements of language communication, etc. And the third bullet point says language 2 will be a language other than language 1. So both languages, and this is the finite list of 20 languages that they have listed. Now, my lords, if your lordships will come immediately, that's all I have to show you from the rules. Just please come to page 50 of this compilation. I had handed this up yesterday. 50 and 51 are regarding those of us who have taken the JTET, which shows the language 2 that we have taken under JTET. Different language. The lordships have that?
That you have said only.
Yes, 50 and 51 is that. Please compare that with 52. 52 is one of them, CTET candidates. So in a CTET, this is the kind of certificate you get. And the language, my lords, on the right side, if you see, paper 2, you see left side also, language 1 Hindi, language 2 English. Two separate papers, one for 1 to 5, the second for 6 to 8. So the languages this person has chosen, language 1 is Hindi and language 2 is English. These languages which we have in JTET are not even available for them in CTET. Which is why, if your lordships come to page 8 of this note, just see page 8 of the note, I've given that comparison. Your lordships can see that.
The new
Well,
data
just
contain
fi-
clauses.
Just finally, on these points,
Page 8.
page 8. Page 8, I've given a comparative table
Yes.
between CTET and JTET with the page numbers. Well, this is my note from yesterday. I've just expanded it to include this point on CTET, JTET comparison.
Yes.
Just two last points. I'll just take half a minute.
Yeah.
One,
Language 2 will be the language other than language 1.
correct. It's just reproduction, my lords, of what I just read out to you.
Thank you.
That's all. Now, just two last points, my lords. One, regarding this note that Ms. Arora has just handed up with these points there, just want to respond to two of them. One about why we didn't implead. All 4 petitions prayers I have here. In all 4 petitions, the primary prayer, as your lordship remember, it came before the advertisement. Primary prayer was only please conduct the JTET, please conduct the JTET in all 4 petitions. Why should I interfere with that? You go ahead, conduct the JTET, it is between you. It doesn't concern me. It concerns me only when the High Court in its impugned judgment in the second para on the last page says it will apply to the ongoing
They
process.
say the petitioners there have not been impleaded as party here.
Here, my lords, we filed an SLP against that, making them parties.
No, she was saying probably.
Association.
Parties have.
No, association. That first writ petition they filed, we can't, it won't even be registered in this court unless we make everybody parties
No, no,
of
this is
parties
what
at the
she
High
said.
Court.
See,
No, that's him.
Petitions
Not
have
correct.
not been challenged. They were,
it's a common order.
my lords, it's a common order
But
in
that-
4 matters.
so
They challenge only the Parimal and the
the
association,
lead
but not the
petition-
one where they are private party.
The
Because
lead-
I
lead-
thought
lead-
you are here now, man.
All right.
Lead petition.
We are.
All right, this is your
And-
written argument. Where is the argument of Mona ji?
ये दिए ना वो।
She submitted it, I think.
Okay. Where is your written argument?
We are just giving it by immediately after lunch because now one more has come.
So many
Much to
things
my
are-
surprise, I said that yesterday also with apology, Manoj.
We do not want to
We
say.
we'll just compile that and give it.
Things are there.
I'll compile
You
it.
give it till end of the day.
We'll do that.
Manoj,
Give it till end of the day.
We'll do that. Manoj.
Madam, your point is this much only. This much is the argument. Fine?
Yes, my lords.
Manoj, by in-
Apologies. I can say only this.
God asked.
See,
No, I understand.
But
My lord's position, I
in all
quite see.
fairness, can we say something? I will say. When we see the judgment and the challenge of the High Court has come before us. My experience here of last more than 3 years is completely, in 50% cases, complete deviation, whatever is before there. Complete deviation. And the case is being made out differently. 1 document, 2 document, 3 document, 4 document, 5 document. In the case of my state, I know everything. I hold up.
Absolutely.
Cannot allow to you go here and there. This case not of my state. It's a case of different state, not a case of the state of brother. We don't know the rules position. We don't know the state, actual state's position.
True.
Then it's a different situation. And sometime what happens, the interpretation come out now, and it really affects the basic purpose to which the rules
Have been made
in that particular state, and what is the purpose.
for the local
It's
conditions.
being applied, no, this is judgment of the Supreme Court, this is a judgment of the Supreme Court. Sometimes we have some, at least, sense of responsibility to place, to say this much. We are not.
My
saying
lords are
anything
right. My
general
lords,
or
we-
anything, but these are-
We really
Lords,
can't.
Anyway, thank you very much.
My lords,
Great.
we are very, very grateful. We are sorry for the inconvenience. that
For
we
the
have
inconvenience
caused.
and the indulgence of
Yes.
my lords.
Not saying, say,
we're just trying to understand the issue.
We understand,
That
my
is a
lords,
lot
but,
of young
but we haven't been
Absolutely.
very
people
helpful.
who seek employment.
No doubt.
Grateful.
Manoj, just one last thing. By that interim order of 26th April, your lordships had directed that all the marks will be kept in a cover.
That is there.
So the consequences of whatever your lordship decided.
Cover it when judgment.
Yes, that's all. That's all.
but it
Whichever.
will take time, na?
Yes.
Take some time.
No, of course, Manoj, it must. It must. No, it'll have an implication across the country, wherever else the same issue will arise.
The law is settled. Therefore, the law across. Will have an implication across this.
And so, keep it in this, keep it. Keep your pledge.
Most great.
Grateful.
Again,
Flash, my lords, great.
our 1% is up. The, it is submission we file end of the day.
By the end of the.
You've handed over.
We'll come after lunch.
Let's.
Submission to transfer.
Yes, please.
Yes, Lordships, in 101, there are 15 cases on the whole, 101 item. There are 15, total 15 cases.
Yes.
Now, in 6 cases, Mr. Neeraj Sekhar is appearing, and I am informed that he has talked to me in the recess, during recess. A request was also made in the morning that he is indisposed, suffering from high fever. I even asked him whether he can join online. He says that it is not in a position because of the high fever. So I'm just requesting on his ground that let these matters go on Wednesday if possible. I know your lordship wants to basically finish this board of 101.
We do not want anything.
Problem is, we have 30 cases with us. This line. When all dictated, then we will set,
Yes,
then correlate,
yes,
then finalize,
I-
then we'll go.
I fully appreciate. My only request that let
Next
this,
Wednesday.
let, on all 6 matters in Ms. Neeraj Sekhar's name is appearing.
All will go 6. We'll not do it piecemeal.
All right, all right,
One day we'll finish it.
all right. Much obliged. Much obliged. 102. 101 advance.
कोई खाली है।
One, please.
You are for the respondent
For the respondent, number 2, TPS.
and you are for,
The state of Tripura.
it is not on this side, this side. It is.
Senior Advocate Mr. Bala Subrahmanyam is leading me, Lordship. He had mentioned it yesterday, Lordship. He's actually on the way, will take some more time, sir. Lordship can have it on Tuesday, Lordship. He was requesting, he just got
But
stuck.
Tuesday it is not at all possible to us.
Tuesday-
We know the problems are, you can understand.
I understand, Lordship. That is why he had
The
mentioned.
one case is heard, it is lying.
Hmm.
Because until we will hear this, we cannot take you.
Lordship, I understand, Lordship. I'm extremely sorry for that. I just spoke to him. In fact, I was not been able to reach Lordship. Speaking, sir.
Lord is keeping it for Tuesday, my lords.
Tuesday is Mr.
I'm so sorry, Wednesday.
Go on Wednesday.
Deeply applied.
Go on Wednesday.
Deeply.
Right.
Yes,
Lordship,
Thaduram.
extremely sorry for this inconvenience, Lordship. Extremely sorry.
Banerjee, you are just laughing only. In which case you are there?
Number of matters.
So start it.
104.
Yeah, 4 is also there. 3 we will pass you. 4 will come.
4 is there, 8 is there. I have a large number of matters before this court. Well, at least I have 4, one after the other before this court.
Come to 4. Yeah.
4 is Ramapur.
You have many weapons in your armory today.
4 is, there are 34 matters now which have been put before my lords. And lordship has seen our affidavit which we have filed.
Now you have filed.
The
The
compliance.
last date,
My lords had asked us, we filed that, then it was placed in terms of lordship's direction placed before the chief. And lordship had asked us to file that compliance affidavit.
before chief,
Yes, my lords.
some
will
other
be-
matters were there.
My lords had then formulated the issues, asked us to file that affidavit and put it before the chief to decide as to which bench it would go.
Some other matters were also there, no?
Yes,
Were
yes,
to be
yes,
clubbed
lordship said,
basically.
put all those matters together and
All have been listed now.
34, whatever I think they have managed to.
Not whatever think.
Well, it's whatever, well, there may be one or two, I don't know whether, but it seems like it's done
Who will
exhaustively.
know if the state or the union will not know?
Well, it's exhaustively, well, we've done it exhaustively. From our end, we have done whatever. Done, Malaz. Malaz, we've given a list, Lordship will see the affidavit. Lordships are with me on the affidavit?
कहाँ है भाई? निकालो. (24/7)
Yes, Malaz. 24/7, yes. 27th August.
No, affidavit in compliance to order 24.
Yes, Lordship had passed that order, then we'd filed it in compliance and then it was filed. Lordship had asked us to get some information. And
You had done some exercise?
Malaz, we'll see, Malaz. Again, to the best of our capability, we've done, Malaz.
Best of capability mean?
Malaz,
Dismissal Solicitor General.
Malaz, we've done, Malaz, we've done.
Union of India.
Malaz, but I know the expectations out of the court, Malaz, so we may always fall short,
Say
Malaz.
more than that.
We may always fall short, Malaz, but well, it's details of cases pending before the Supreme Court, Malaz. That's annexure A1 at page 6. So we've given all the details, Malaz. There are totally, before the Supreme Court, Malaz, there are 34 of matters pending.
How much is the financial effect of all these?
So that we have said, amount, court cases.
These 34 cases.
Malaz.
But you said in the high courts also there are pending.
There are, Malaz. We've court cases pending. That is at A4, page 19, Malaz. That is the number of cases pending in the High Court. Malaz, then I'll take Malaz through the amounts which are pending.
Odisha, Bengal, UP, Punjab, J&K, Himachal, Goa, Kerala, MP.
Bihar,
These are related to
it's all of them. Malaz.
these issues only.
Yeah, I'm sorry, Malaz. Yes, Malaz. There seems to be 462, according to us, in the High Courts.
Right?
Malaz, I'm sure there will be now a large number of people.
In the
Goal is
matter-
clear, you say large. There is no goal paper.
Calcutta.
Well, they were the lead, but now let's have expanded it so they would be large.
Nowadays, uh,
104.2.
Page 16. And a very interesting thing, Malaz, we've enclosed is that benefits.
But do you have other cases, any other matter which can be finished today? Because we have
I
partnered cases.
I have, Malaz, I have.
This is not likely to finish today.
Malaz, I will.
We can't mix the partnered cases. 3-4 partnered are already there.
Small one, Malaz, I have Anshu Pandey is there. With
Yes,
108,
which we can finish today only.
108, but on the other side is Mr. Gupta. I don't know whether.
He is there behind you?
108, Mr. Gupta is there.
He has
Malaz,
got
that-
hold of you.
I was just told.
He has eyes on backside also. He had seen you have entered the room.
Union has eyes all around.
Yes. Sastra Netra.
No, I will go on that side. This matter, I'm on this side.
I saw 104.
This side.
Lordships are not taking 104 today.
We were seeing because this may not finish today.
This will not finish
We
today.
have 2, 3 part-heard matters which have switched over to next week. So this will also then intermingle.
Part matters. We are thinking that let it be finished. Otherwise, in one part, already 30 orders we have passed, 15 has to pass.
Yeah.
But like
That whole batch of 40 odd, Mulad, item
Contempt petitions. were
Yes,
there.
yes, I have.
So that
lying
creates-
here and there.
Otherwise, it won't be decided,
No.
Mulad. Your Lordship has taken it up.
Your judgment in those cases also,
No, no, very difficult, Mulad.
because we have to see the rhythm of every judgment, no?
Yeah, no, absolutely.
It's a problematic. Then
Absolutely.
the next case gone,
Yes.
So 104
then
can
third case
remain,
gone,
104
Now
can
fourth
remain in the
case.
court minutes.
Yes.
104.
What we are thinking,
Will
some
remain
case
in the-
which can finish today.
continue with board, because we want to finish this
No, no,
freedom fighter.
Yes, Mulad.
Right.
108 will also frankly take time, Mulad. Even earlier, your Lordship.
Today it will finish? No.
I don't. Last time, your Lordship heard it for about an hour earlier, Mulad.
Is that cadre?
Yes, yes, yes.
Change of cadre.
Yes, yes.
Yes, Lordships,
It will take again at least 2, 3 years.
Yes, yes.
Mulad,
My Lord heard it earlier, Mulad, sitting with my Lord Justice Vishwanathan, Mulad.
No. It will take time, Mr.
my learned
Banerjee.
friend wants to make that submission of 2 hours. I know what my learned friend,
No,
Lordship,
no, my Lord heard it for over an hour earlier and.
but our,
I have seen that judgment. I have seen that take time. Mr. Banerjee, I have seen that.
One of the rare matters
To be,
where the tribunal says it's arbitrary what has been done, but we won't give any relief.
but Malad,
Patient successful,
23
patient.
23
Patient
years
died.
later, Malad,
huh?
to upset the entire.
We've given a mechanism for that. We filed an affidavit explaining that.
Malad, that may be, but Malad will also see. the
Let it
impact
go
of the-
probably in November.
Whenever it's convenient to your Lordship. I understand, Malad, your Lordship
October, you
doesn't
can
want.
understand.
Yes, yes, 2 weeks are off, Malad, and your Lordship already has too much on your plate. And then you have that other matter, that miscellaneous 8, which is next week on Wednesday, Malad. That's the other matter, which was there yesterday. Yes, Malad.
UP.
Yes, the UP, that entire thing, which is going to take Wednesday, all of Wednesday, Malad. That's on Wednesday, Malad. That's on Wednesday.
That's the 3, 4 matters are there, so.
Yeah.
These must go then in November. We are in count.
108, Malad.
Now,
What is it, 105, who is there?
Lordship, oblige.
105, who is there?
Malad,
Haryana Public Service Commission. Oh no, again, this is again the.
Why just-
This is a matter where my lord had issued notice to the learned Attorney General for India. Because he is,
Of India, what happened in this?
was in fact on the,
This is the matter in which the Public Service Commission, all the public service commissions must hold their interviews with video conference, with video recording.
Recording.
Alright, so that was the issue involved. So Attorney General were requested to hold a meeting of everyone
that's right.
in this case and to apprise us what happened.
find out. I'm
You would not be aware of it.
not aware, but I'll find out.
Attorney General is here.
My lords, I am not, I'll have to,
Yeah.
It's in a-
Okay.
my lords, I am not sure.
Morning,
In
you-
fact, my lords, last time I had inquired, I think the matter was he had requested Mr. N. Venkatraman AST to appear. Lords, he is on his legs in court number 1, that much I know. But
Not Venkatramani. Attorney General was asked for.
that's right, my lords.
We are aware, I am appearing, I'm.
Lords, that was only because the learned AG was probably not there on that day, my lords. For today, my lords, I am not sure.
He asked,
Certainly, my lords.
please kindly ask about this matter from Attorney General. Because issuing a direction by this court, you can understand the impact. Go and hold a,
I appreciate.
and on the other hand, some issues are also there. So how it can be resolved?
For best interest for everybody.
Keeping it, you please apprise us.
Yes.
We are keeping it. Next year, 106. Wonder, this case.
Lord, in 106, I'm seeking 1 week's accommodation. The council is before another court.
November. November. And the request is State of Punjab.
Wait, please.
Captain Satpal.
Lord, item 107 is a rather short matter, I would say, Lord. It's a matter pertaining to dismissal of an employee. He is commando in the Punjab Police, and he's been dismissed for service in the year 1996 for remaining absent for 37 days. Now, the question that is, after the dismissal, he's filed a civil suit, lost, filed an appeal, lost. In the second appeal, a question of law was formulated. The question of law was twofold. Firstly, whether in the absence of writing to him in the show cause notice that previous conduct will be taken into account. His previous conduct of remaining absent can be taken into account. And the second related question is, under the Punjab rules, there is a requirement to take into account his pensionable service that is left, whether that has been taken into account. So on that basis, in the second appeal.
What is his age now?
Lord, I'm not aware of his age, Lord, but he would, he joined in the year 1989.
He has still have
Relevant.
time. Still have time.
He have time.
He still have 2-3
He
years.
still have time.
4-5 years.
Yes, Lord. The High Court
I
had,
was informed last time this was, he was 55 years.
yes, ma'am.
55 years, I believe.
It's a post of constable in the commando. He was, at the relevant time, he was commando, Lord. Lord, otherwise, the question of law, Lord, is covered.
Just in 94.
The show cause notice is 94, termination is 96. And my Lord, he joined the services in 1989.
Declaration to the effect that the order impugned is illegal, null and void, ineffective upon the rights of the plaintiff. And then all consequential benefits, including seniority.
But he had not been granted back wages.
Back wages denied.
Yes. But he has not challenged that part. Yes, ma'am.
Where is the order of dismissal?
Yes, my Lord. The order of dismissal, my Lord, is at page 19 in the IE, my Lord, for additional document they had filed, my Lord. In this matter, you
Everything is the problem in the Supreme Court is,
yes, my Lord.
everything is with the IAs.
Lord, I am sorry, my Lord, for that.
Everything is the IA and everyone says sorry.
Dispense with the rules all. You should have given here only in the court. System is one by one, papers come.
So Lord, I apologize for that. Actually, my
No,
Lord,
that's the only thing. Sorry, apology, that's all.
your Lordship had permitted us by order to file it, my Lord.
Yes, yes, we should have not.
No, my Lord, I am not saying that at all.
We have done a mistake.
No, not at all, my Lord. Your Lordship has been very kind, my Lord.
We are doing in our court, we are starting doing.
Band karo.
We have already said about marking of the presence in our
Yes,
court.
yes, yes.
We start doing in our court.
Lord, IA number 780, if your Lordship has, my Lord.
Yes, where is the order of dismissal?
Order of dismissal, my Lord, is at page 19, my Lord.
Page 19.
Yes. 17, P7 is where it starts, my Lord. Show cause notice and followed by the order.
Record as?
Sorry, morning.
Lord, the record had come and sent back.
What do you want to say?
Lord, as per the previous office report, the record had come, but under the rules, it was sent back to the High Court.
No, soft copy is there.
Please ask. Please ask. आज भी डिसाइड हो.
कॉपी तो रखनी चाहिए, मंगा लिया, भेज दिया, क्या मसला हो?
I'll prepare a short list of dates the Lordship will find.
Just let us see the record.
After. It's not updated by numbers. Why is the bill? Yeah, 2012. Mhm. She's going one submission section.
Order passed in the revision to him?
No, here in this case, there was some rule.
Yes, Lord.
Under that rule, both situations can be taken to consideration if I am not incorrect.
Lord, yes.
So remember my,
Rule 16.2, your lordship is absolutely right.
some rule was there.
Yes.
I am emphasizing to my memory. Where is that rule?
Lord, that rule,
Yeah, police rules.
yes, yes. Lord. Lord, at page 10,
Page 10 of application.
no, Lord, page 10 of the SLP, Lord. It's reproduced, Lord.
Page 10.
Page 10, yes.
Continue, misconduct.
Dismissal shall be awarded only for the gravest act of misconduct or as the cumulative effect of continued misconduct, proving incorrigibility and complete unfitness of police service. So you say that your case may fall within the purview of 16 to second clause,
Lord,
or as the cumulative effect of continued misconduct, proving incorrigibility and complete unfitness for police service.
if your lordship, yes, Lord, that's like one part of my case. And my lord, the impugned order actually takes into account previous conduct for the purposes of affirmation of what has happened. But still,
Here you fall within this category, no? But we have said.
yes, my lord, my submission in that is that there are line of judgments which say that even in armed forces.
No, we are not, sorry. Will not take those. In some of the cases, we can take into account.
Yes, my lord.
In some situation, it is not, but we will go the rule 16(2).
No, absolutely. I'm within the framework of the rule 16.2, my lord.
You-
Rule
you-
16.2 first says
not-
gravest. Gravest. my lord.
And therefore, you want to say that if we see the date of events of this case,
Yes, my lord.
chain of events,
Yes, my lord.
so dismissal would be of the gravest act of misconduct or
Or, yes.
as the cumulative effect of continued misconduct. So you want to say this continued misconduct of earlier 3 times. He was awarded punishment for
Yes.
three times.
3 times.
So now, so as a cumulative effect of the continued misconduct,
Ye-
now again he was absent.
Yes, my lord.
So misconduct proving incorrigibility and complete unfitness of it.
If you,
That is the crux of the matter,
that's,
not there.
One thing is there,
yes,
This is on the
just
question of.
see your list of dates.
yes, my lord.
He was appointed in 1989.
Yes, my lord.
First punishment is 94.
Yes, my lord.
5 years service forfeited.
Yes, my lord.
So how much service will remain in balance?
My lord,
89 to 94. 5 years only he had served.
yes, my lord.
5 year you forfeited.
Yes, my lord.
So he came back to the bottom again.
For the purposes of accounting pension, my lord.
Yes, yes. So what remains now? You have 17 years already forfeited.
Yes, my lord. So, my lord, that's the reason, because it's 16.2, the second part also says that when you are awarding the punishment.
And you
should
did
also-
not have, to his credit, any service. In fact, when you impose the second punishment,
Yes, my lord. So
how
that,
could you foresee that he will serve more?
no, my lord, for the, so,
Not for the, just see,
Yes.
second order is also 94.
yes, my
You
lord.
forfeit 5 more years.
Yes, my
He
lord.
does not have any service to his credit.
Yes, my lord, for the purposes of,
You ever assured that he will serve for next 5 years also?
my lord, for the
In
purpose,
advance, the punishment is there.
my lord, for the purposes of counting pension, this.
Again,
expenditure is
pension.
there. My lord, so his,
He has any service to his credit on that day?
my lord, he has, my lord, no.
Then
Not
what
for the-
kind
not-
of punishment is this?
My lord, not for the purposes of
Again,
pension.
again? What kind of punishment is this?
He may continue to, my lord,
How can you be sure that he will remain in service?
my lord, that's one of the considerations that has to go into, in under 16.2 while awarding the punishment. My
All
lord.
right, let us understand.
Yes, my
Which type of punishments are there in the rules?
lord. My lord, there can be, my lord, for the, for
Where is
gravest,
that rule? Where is your rules?
my lord, the rules themselves, my lord, we have extracted the relevant dismissal.
No, 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 not concern of dismissal.
Yes, my lord.
There must be a type of
Yes,
punishment.
a major penalty, minor
So
penalty.
where
as
is-
is-
Where is that?
Maybe it's a general, major, minor penalty. Court is asking. Well, I'll just take that out, my lord. My lord, those rules, the full length of the rules are not on record, my lord. My lord, I'll tell you,
That also, sorry.
my lord, if we are.
The appendix required or not required?
No, of course, my lord, it is
Not
not. With
required.
greatest respect, your lordship,
Not-
kindly see, my lord, that this question arose in the context of second appeal. The limited question that the second appeal had examined is only for 16.2.
We can't see anything more.
My lord, my lord, in 16.2,
Where is the revisional order?
lord, the revisional order is not on record, my lord.
So that is also not relevant. The punishment, appellate, revisional order which were challenged, not relevant.
My lord, my lord, the punishment orders, my lord, will till.
That you have shown.
Show cause notice I have filed, punishment order I have.
Appellate order, thereafter revisional order, not relevant.
My lord, those we have not filed, my lord, because,
Not relevant?
no, my lord, for the because, my lord, the object, but the delinquent had gone in second appeal, raised a very specific and narrow ground, my lord. Your lordship will give me time, my lord, I'll place all of that on record.
Probably what you are doing is the question which was asked by you.
Yes,
So if you say that 5 year service forfeited,
yes, my lord.
probably some, what I recollect and the rules, study of the rules, other rules, it is 5 year past service.
It has to be
It is not 5 year
future
service,
service.
past service, always.
Yes,
Forfeiture, if you are doing of a service, means it
Thing
will
has
be a
to be there.
service and account.
my lord,
So we want to see the word past service,
my lord, I'll get the rule.
or it is service.
I'll file the entire.
So it can be whenever the service is coming in account in future, can be done.
Lord, I'll get the rules.
Advance punishment.
Advance punishment.
Lord, I'll get that.
So primarily, this question is having relevance and asking of the
No,
rules.
I see that, my lord, but none of those.
5 years total service and in 94 you impose forfeiture of 17 years of service.
Lord, yes, Lord, I quite see that. Lord, these are all disciplined forces. He's a commando. He's habitually absenting himself from duty.
Have you understood the question?
I have, my lord. I have.
What is the answer?
Lord, I'll look into the rules, my lord, whether the rule allow forfeiture of
You
past.
are arguing without the rules being with you.
Lord, I have the rules. I don't have the copy for the rules, my lord, because
Very
because this question did not arise earlier.
Very good. There is the SOP here. So why are you different? It should not be different.
Your lordship will just allow me, Lord. I'll file the complete
Yes,
rules.
yes.
I'll file the revision in the appellate order. Lord, I apologize.
Only this is pending for 12 years here only, nothing.
Lord, I apologize, Lord.
And by the time it will be taken up, he will have the age of
Lord, the question,
superannuation.
Lord, the question was actually narrow, Lord. That's the reason, Lord. I bow down. Your lordship will give me a week's time. I'll file everything.
We are not required to see anything else.
Lord, those with great respect.
Honorable Counsel, may I ask one question?
Yes, sir.
You are saying that the question of Rule 16(1) interpretation is involved.
Yes, 16(2), yes.
Once we see the interpretation of 16(1)
Yes, Lord.
or as the cumulative effect of the continued misconduct proving incorrigibility and complete unfitness to good service.
Yes, my lord.
So when we see this cumulative effect of the continued misconduct,
Yes, my lord.
so when we look into, then we look into your punishments.
Yes, my lord.
And if we look into your punishment, then this question arises.
Yes, my lord.
So you're saying that it was question of 16 only,
So I bow
but you
down.
cannot look at
I bow down to your
how
word.
far you are just, we are unable to understand.
Lord, I bow down to your lordship that the entire rules should have been placed on record. I'll place them on record. I bow down to your lordship. I see what.
You want that whatever you want to show that we have to show.
Not at all, my lord.
We have to see that much.
Not at all, your lordship. I'll file the complete rules. I'll file the complete.
Next year lag also. Complete rules are not on record. It's by rules and the judgments. And the 11th orders are not on record. It be filed this next year.
Madam, any specific date may be given?
Next year.
2025.
Lord, in November, if it is possible.
Lord, I apologize, Lord. Lordship will forgive me. Lord, I'll make sure that everything.
January.
Please do adjourn 108. Mr. Gupta is only. But Malats 105, I have instructions. But Malats had asked me to take instructions for the learned attorney.
Public Service Commission.
Yes.
Yes, what happened?
In court number 6, there's a final argument going on since 12 o'clock. However, your lordship's query is whether he has had the meeting. He has had the meeting with and called for responses from all the state commission. We are informed that 2 state commissions, which is Tamil Nadu and Assam, they say that they are already in the practice of recording the interview process by way of a videography. Rest have declined it. So Attorney General would like to assist the court on this matter. My lord may have it after 2 weeks. If the court says 111 is
January mein. Next.
But I am prisoner in 109.2. So Patwaria is leading this matter, madam.
What are these matters?
These are matters for the
Who is for the state?
I beg to appear, my lords. My lords will recollect these are, my lords, those 0 district where there were no vacancies. These are teacher appointments. I'm sorry. My lords,
Take breath. Take breath first.
please, my lords.
Your lordships have heard this for some time. Now, frankly.
Just I am recollecting that because of 2-3 matters.
Yes,
Initially, I have not seen others.
Lord,
I have not even touched. Initial 2-3 matter, I was thinking that it will come and it will finish.
So, my lords, these are issues with regard to teacher appointment in state of UP, my lords. The recruitment was made district-wise, and whichever districts there were 0 vacancies, candidates who had taken the BTC courses outside of the district were permitted to apply. That is the controversy. Your lordships heard it for some time. And my lords, yes, 15,
the appointments to be made.
15/5/24, your lordship's order. My lords had allowed the application of the state and permitted us
Yes.
to make the appointments. So the matters have to be heard now, my lords.
But there is an application by me, my lord. I am a person who was selected, my lord.
My appointment order was not given because for the reason that there was some deficiency, which I have cured. But because of your lordship's direction that only 5,000 not people to be appointed, that is kept holding. Your lordship, I moved an application, for improvement and for direction,
We will have to
Lord,
get
it's a-
instructions on that.
This matter, my lord, essentially.
Other districts, they have allowed it. I have filed that order, so.
Some kind of arrangement, because, my lord, your lordships have permitted a substantial number of people to be appointed. Now, my lord, we are representing, my lord, what had actually happened in the recruitment, well, the rule says if a particular person has undergone a training in that teacher BTS course, he shall be entitled to be considered for that particular district. But in some district, there was no vacancy notified at all. So the rule said, in respect of such candidates, my lord, where they have undergone that particular course and no vacancy is notified, they will be given an age relaxation up to 50 years. But they cannot compete, my lord, for other districts. So, my lord, there was a challenge by them onto this. The rule says specifically says that you'll be considered for the district where you underwent that course. So, my lord, that's the challenge in these matters. Now, my lord, in the course of hearing, my lord, your lordships have also permitted, considering the fact that in most of these schools there are no teachers, etc. My lord, lordships have by interim order also allowed those from 0 district, my lord, vacancies, they have been allowed to be absorbed. Got the practical solution way out. My lord, we have also, my lord, I represent, my lord, the clients in a particular matter that is
Practical
109.4.
solutions can be have with Shwarya ji.
It only can find the solution.
Yes, that's what, my lord, we are also saying that only because, my lord, those people, my lord, who applied from a 0 vacancy district, they have now, they applied for the other district where they were notified, the rule applied. That is only, it was reserved for those who had undergone that course in that particular district. Because, my lord, the course involves, my lord, a 6-month my lord, internship with the students in that particular school, in that particular area. So the objective appears to be that the teacher and the taught are communicating the same dialect. So that seems to be the objective.
जो है सब
So, my lord,
anyway, we should start.
lordship may have it some,
Not, it will not finish today.
no, it won't, my lord. Because, my lord, we have to give some practical solution because what we find is, my lord, there
You
is.
give it to her, then
No,
let
my lord,
them examine.
no, my lord. Yes, that's what I also want because we have found.
Some solution.
There is any solution you give it?
Yes, my lord, the solution is we have taken out RTI and there are several.
Just please.
My lords, when your lordships were hearing it for the interim, that stage, my lords, your lordships actually heard it substantially. We suggested
We are aware
some.
of that. We are-
Please, my lords.
On that day, we have not reached to any of the conclusion. I was.
Yes, your lordships.
But we have not reached to any
Please, my
substantial
lords.
conclusion.
Please, my lords.
Because of the, you have said because of the new session is coming
Yes, my lords.
after vacations.
Please, my lords.
So we permitted you to join.
Please, my lords.
Check to find out.
Please, my lords.
So that is merely, we have made it clear that they would not have any right.
Please, my lords.
It is whatever the order is being passed.
Please, my lords.
So whether it would not be proper that what solution they are suggesting to
Not-
examine it.
No difficulty, my lords. We should examine it.
Because we know this will not come in October. This
Please,
will
my
go in November
Please, my lords.
for any reason. In the meantime, you examine it.
No difficulty, my lords. We'll put
We are
it.
not mentioning this fact.
Yes, my lords.
We are not mentioning,
Yes,
but it is an understanding. You
Yes,
can examining this.
Yes,
There are about 760 petitioners before your lordships, my lord. And I'm told
No, I have
there are
filed-
about 781 vacancies. But that's our information under RTI.
781.
81 vacancies in the same recruitment, unfilled. So they can consider us, my lord. We want an equitable.
If they consider us, we are not coming in the way.
Very well, that's.
We are not coming in the way. If they can consider, they have eligibility.
Yes, eligibility is not.
We'll have to check, my lords.
check it.
Yes, my
They
lord.
have eligibility and they have passed it out the test.
Please, my lords.
You can see. look
I
in-
bow down, my lord.
If can be
But this is
possible.
done
Lord,
by
I-
counseling.
I
There
have
is
filed an
there is no
application, my
recruitment
lord,
test.
for
There is by-
implement.
Done by counseling.
I was selected, my lord. There are about 31 people, my lord. We are selected, but our appointment was kept in
What the
abeyance.
government is saying, let us understand.
Yes.
I will have to get instructions on his application.
When the selection took place?
Oh, that is like.
Lord, this was in 2023, my lord, 2000. 2004, January 2004, my lord, 7.
January 2004.
You please
Yes,
apply.
sorry, 224, my lord. 2024.
Elections took place in January 24.
Yes, my lord.
Advertisement is of 2016.
Selection.
So 2024, my lord, we have, our letter is 2024, there is an order taken out, my lord.
There are
You are
two
selected.
dates, please. And now I am remembering everything.
Yes, my lord.
One is of December 23 list.
Please, my lord.
And the another is of January 24 list. If I am not incorrect.
That is correct.
Now I am recollecting everything.
Please, my
Yes.
lords.
Yes.
That,
And when it is, the data is coming.
yes.
Your lordship.
And the
Yeah,
advertise,
please, if I am not incorrect.
and the
Suppose this
advertise,
is your appointment of like this.
please, my lords.
Then you please examine this.
Please, my lords.
His case also.
Lordship.
We are not passing any order.
Please, my
We'll
lords.
see, in one goal, we'll pass the order.
Please, my
otherwise not.
lords.
That's
But in-
No, I will, we have served the copy on them, my lord, we'll give another copy to my lord. Yes, my lord.
देखिए,
Huh?
Yes.
नवंबर में कोई डेट लगाइए मैम, सेकंड या थर्ड वीक, वेडनेसडे को है, वेडनेसडे को,
Please, my lords.
सेकंड या थर्ड वीक ऑफ नवंबर.
November.
November. Grateful.
Grateful.
My lords, lords, may I crave my lord's attention in 109.2, my lords. I was not unmuted before, I was raising hands.
Yes.
My lords, even I have moved an application bearing number 189977 of 24. This represents 93 candidates who have better cutoff marks, quality point marks. Even my
We are
request would be,
We are not hearing it.
no, my
We'll
lords,
hear-
like my lords have said for the, to the
Madam,
learned
we will look
Solicitor
into-
General to
We'll
consider my
your
application
at
for,
that
for the
time.
purpose of my lords.
Madam, today there is no reason to consider this separately. We'll consider it along with merit of the case.
Lords, it's only pursuant to my lord's last order to consider me for appointment in the meanwhile, my lords. We
Madam,
all,
I
we
will, my
all are lords above the cutoff
Please.
marks.
Madam Gupta, you please apprise to Aishwarya ji. He will look into.
I'll give the application. Grateful.
Please, your lordship. Lords, I am appearing for the petitioner in this.
Yes, please.
Lord, if I may.
This is against some interim order in contempt petition.
Correct, my lords, where I was
is the-
directed to comply with two of the previous judgments. One is of 2016, which judgment says that you comply with the earlier judgment of 2011. That I have complied with both those judgments.
Then
There I was directed.
inform the High Court.
My lords, I have informed, I have complied with the direction.
Let the order be passed. This matter is still pending.
My lords, the order has been passed that I have not complied. Rokar has been framed against me, directing that I have not complied with the initial judgment. If my lords, for a moment, may I have page number 32. The order at page number 36. My lords may have the direction at page number 33 in the initial judgment, which I have been directed in the last. Last paragraph, my lords.
No. Now this here, the impugned judgment is,
Impugned, there are three orders, my lord,
yes,
which are wherein
Page
contempt
30.
petition,
Yes, yes.
please, wherein contempt petition has been filed, my lords, for contempt of judgment dated 12/12/2015. It starts at page number 56, my lords. If my lords may have page number 58 for a moment of the SLP paper book. First paragraph, my lord. This is the last judgment of which contempt has been alleged against me. Page 58, my lords. It begins with page 56, the last judgment. I am reading the third internal page of that, which is page 58. The matter was to be considered by the official respondent to settle the controversy about filing and non-filing of the application forms by the private respondents within the cutoff date.
Please. Please refer the orders. Impugn, then correlate those orders.
Please, my
So
lord.
what is the impugned order? Come to that.
Please, my lord.
This was an order.
My lords, the
Then what is this order? This is of 19/10/20.
19/10/20, my lords. In this, my
What
lords,
this order is there?
if second
What
paragraph,
is wrong and objectionable in this order?
Page 2.
page 2, my lords, that car has been framed against me.
Yes, yes, why it has been framed?
My lords, for non-compliance of,
Which order now? Let us see.
please, my lord. My lords, the judgment dated 12th of December 2015.
Where is that mentioned in this order? In this order, we don't find anything. Reportedly, department file SLP, which is pending. Which is that SLP?
Present is,
Page
my
1.
lords.
Which is that SLP?
This SLP? This SLP was filed before passing of this order? Page 1.
The department has filed SLP. What is this SLP?
Against the judgment of division bench which is pending.
What is the date of the
Contempt
division
needs to
judgment?
be deferred.
What is the date of the division bench judgment?
Lords, that,
This is the
Before
first
chilling
paragraph.
this order, please.
my lords, if I may apprise
We're
that,
just flying on 50 step. We are on the first step. Page number 1. Please show where is this SLP? What is the reference of this SLP? Against which judgment this SLP is there?
my lords, on this, I have to seek instructions.
On what basis you are asking any relief here? You have to seek instruction on a first point.
And this is the basic thing. You should have mentioned that in the petition only. And next para also it mentioned aforesaid summation was made by the Leonard Senior Additional AG way back on 29th January 2020, but no such restraint order or proceeding pending before the Supreme Court has been placed. Maybe you had misstated the fact there.
My lords, if
We
my
do
lords
not know.
have page number 10, that is the third impugned order.
Again, you are not answering the first question.
Lords, for this SLP referred in this, I have to seek instructions because I'm actually not aware, but if my lords will see page number 10, which refers to 12th of December, order of which contempt has been alleged. Page number 10, my lords, third paragraph.
What is this order of 12th February 2015 passed in SWP number 2542 of
Is
12?
that page number 56, my lords, annexure P5.
Whether this judgment was challenged before the Supreme Court?
Nobody knows.
Whether this judgment was
Lord-
challenged before the Supreme Court?
To the best of my knowledge, it has not been challenged, but
We can't decide on your best of knowledge.
well, my lord, I don't have a clear instructions on this, that whether this particular judgment has been challenged or not. However, it has not been challenged.
Suppose it is not challenged,
Please, my lord.
then compliance of this order has to be made,
Correct, my lords.
and you have not made the compliance.
My lord, that's what I'm trying to show, that I have made the compliance.
So
I'll
then
show the
compliance-
order, my lord.
Yes, please. So in that situation, suppose you have made the compliance,
Please, my lord.
you file the reply before the contempt court.
Yes, my lord.
Like they have a jurisdiction of 215.
Yes, my
This court have a jurisdiction 129, Article 129. They have jurisdiction of 215. You file the reply. Primarily, they are of the view, yes, charge has to be framed. Framed, it will be decided if you have complied. Why you are worried and why we should interfere at the stage
lord,
of that framing of charge?
If my lords may permit me only 2 minutes, my lords may have page number 58 for a moment.
58.
The compliance which I'm trying to show. Page 58, my lords, first line, my lords. The matter was to be considered by the official respondents to settle the controversy about filing or non-filing of the application forms by the private respondents within the cutoff date. Now, my lords, what has happened? In 2007, an advertisement was issued for engagement of teachers under a scheme that was Rehbare Talim, which was subsequently withdrawn in 2018, and all the pending advertisements in which selection has not been made or no appointment orders were issued, that has also been withdrawn. So effectively, the advertisement under which this whole litigation has been contested, it has now stand withdrawn because no engagement order was issued in this also.
There are already
When-
orders
when
in
it
the
was
favor of
withdrawn,
this.
When this
No.
was an order passed on which date?
My lords, it was initially
This was
passed,
an order passed on February 2015.
correct, my lords, prior to that.
So
But
when
there
did
was
it-
no challenge has been made, my lord, with regard to their engagement. There was no direction to appoint them.
We are not supposed to examine everything here.
No, my lord,
Content
I'm only informing this particular fact.
So
If-
go and examine there.
If my lords may
Contest there,
my
no,
lords-
they will look into.
if now, my lords, with regard to this cutoff date, in 2007, after issuance of this advertisement, few of the respondents were, few of the people were candidates were tentatively selected in the tentative panel. Then subsequently, the respondent number 1 to 3 herein filed a writ petition that few people have have made an application before the department that they have
Let us
also.
understand, don't go to this. The matter was to be considered by the official respondents to settle the controversy about filing or non-filing of the application forms by the private respondent within the cutoff date.
Correct, my lords.
So what you decided, please.
My lords, may
And
have
what-
page number
what-
36. That
Page
is the
number 36.
36. That is the order passed pursuant to the first judgment. For a moment, my lords may also have page number 33. That is the first judgment. And the direction contained there in the operative part, my lords. My lords may have, my lords have page 33.
Why we should look into 33?
My lords,
We are not required to
my
look
lords may
into
have page
everything.
number 36. Para number 8, my lords.
Para number 8.
Page 36, my lords, para 8. Whereas after proper scrutiny and verification of the records, 4 candidates stroke aspirants who too have applied for their engagement within the fixed cutoff date have been found eligible, but due to some wrong assumption, they had inadvertently been dropped.
Para 30, page 36.
Page 30.
Para 8.
Please, my lord.
Whereas after
Please.
proper scrutiny,
Please.
read it.
Whereas after proper scrutiny and verification of the records, 4 candidates or aspirants who too have applied for their engagement within the fixed cutoff date have been found eligible, but due to some wrong assumption, they had inadvertently been dropped from the list of eligible candidates and subsequent impanelment. Whereas the ZDO Achabal is in support of objections claim provided all the relevant records justifying the in-time submission of their applications within the fixed cutoff date, that is 6/1/2008. It is settled position of the law that mere figuring of so-and-so. I'll skip that, my lords, and I'll come on the last paragraph, my lords. Now, therefore, in view of the aforesaid court orders and the stand taken by the zonal education.
Where is there? Now therefore.
Please, my lords. Achabal, now therefore, in view of the aforesaid court orders and the stand taken by the zonal education officer Achabal, she is advised to proceed ahead with regard to empanelment of above 4 objectors by reframing the panel of all the aspirants who have applied for within the fixed cutoff date, provided that they are otherwise eligible as per norms or guidelines of the scheme, and submit the said panel of candidates to this office for further appropriate action. The tentative selection list issued with a so-and-so dated 25/9/2010 in view of above background is ordered to be withdrawn ab initio.
How this order can be said to be an order after 15? This is an
My lord,
order of
no,
2011.
No, my lord, this is the order prior to that only. I'm showing that the direction.
So what is the relevance of this?
3 rounds of litigation.
My lords, the initial judgment directed me to scrutinize that whether these 4 people who are later on empaneled.
How many persons filed contempt petitions?
3, my lords, only 3. Only 3. Respondent number 1 to 3 herein.
This order was passed at page 56 in a writ petition of whom?
In a writ petition of respondent number 1 to 3 here.
This serial number 56, Sahnaz Parveen and another.
Correct, my lords.
You have referred this order, no?
Correct, my lords. This is the last order
How
of
many
which
petitioners
contempt.
were there in this case?
3, my lords.
There are
Where
many,
is that?
there are
No,
many.
there are in pleaders. Here in the SLP, there are in pleaders.
So please, from where we can gather, these are only 3.
Please, my lords.
हाँ तो ये कितने बाबे हैं?
My lords may have page number 61. That is of parties of contempt petition. Shehnaza Parveen, second Gausia Yusuf, third Riaz Ahmed Shah. They were the original petitions in the 2011 writ petition also, in pursuance of which I passed the order which I just read at page 36.
Please, learned counsel. Probably we are also a part of this institution and we have done all this job. From a long. Don't do all these things with us. Huh?
I'm sorry, my lords.
Otherwise, we make some observation against you also and pass an order here. You will be in trouble in future. We are asking at page number 56, it is an order of the writ petition. It says 2542 of 2012, in which Sahnaz Parveen and another, how many another? You are referring a contempt case. This contempt may have been filed by 3. How you can say that this is equal in the writ petition?
Lords, I'm sorry for that. These were the 3 writ petitioners who subsequently filed the petition also.
Reaching to a question, we have to face at least 20 puzzles. Not referring even a paper.
Memo of parties of the writ petition is not on record.
Then why you are referring this? That we should write, you are misguiding us.
I'm so sorry for that. I'm